Imagine you're navigating a complex legal battle, maybe defending your company against a pretty big claim.
Right.
Now, picture this. The other side, they aren't just funded by, their own cash or a bank loan.
Hmm.
There's this third-party investor, totally unseen by you, pumping money into their case. And that could change everything, right? Their whole strategy, how long they can wait it out, their willingness to, go the
Yeah,
distance.
you have no clue who they are.
Exactly. No idea how much leverage they have or what kind of return they're looking for.
That hidden player, that's third-party litigation funding, TPLF.
Hmm.
And, what our source material really drives home is that this isn't some niche thing anymore. It's huge, a massive growing industry.
And it's having a big impact, particularly, it seems, in cyber insurance litigation right now.
A really striking impact, yeah.
Yeah.
Maybe even alarming in some ways.
Okay. So our mission for this deep dive, then, is to really peel back the layers on TPLF, based strictly on the source material we've got here. We need to understand what it is, why it's just exploded, why cyber seems to be such fertile ground, and crucially, what it means for the costs that, everyone ends up paying.
Yeah, because this isn't just some abstract legal concept.
Yeah.
This invisible hand, as you called it, it's really shaping how long cases take, the tactics involved, the final settlement numbers.
And those costs eventually hit policyholders, consumers directly.
It just completely shifts the dynamics, doesn't it?
Yeah.
When you have this external player involved, purely looking for an investment return, kind of messing with the normal dispute resolution process.
So let's start with the basics then. TPLF. What is it, fundamentally? What's the mechanism?
At its core, it's pretty straightforward. An outside investor, could be an individual, could be a whole fund, gives money to a plaintiff or maybe their lawyers.
Okay, covers costs.
Yeah, litigation expenses, think expert witness fees, discovery costs, sometimes even living expenses for the plaintiff while the case is ongoing.
And what's in it for the investor? What's their payoff?
So, in exchange for that upfront cash, the investor gets a slice of the pie, a predetermined share of whatever the plaintiff wins, whether that's from a settlement or a court judgment.
Right.
And a really key point the source highlights. These funders, they have zero direct connection to the original problem.
Ah.
No stake in the actual dispute itself. They're purely financial backers of the litigation's outcome.
So they weren't hurt in the data breach. They weren't part of the business deal that went south. They're just looking at the lawsuit itself as an investment.
Exactly. It's often pitched, as a way to help claimants who might not have the money to pursue a valid case, access to justice, that sort of thing.
That's one side of it.
That's one side. The other side is, well, it's a way for funders to potentially make some serious returns on their investment.
And I guess those potential returns must be pretty good because the growth numbers in the source, they're kind of eye-popping.
They really are. Global investment in TPLF, it hit $17 billion back in 2021.
$17 billion. Wow. That feels like a lot for something most people haven't even heard of.
And it's not stopping. The projection takes it way higher, expected to hit $31 billion by 2028.
Whoa. Nearly doubling in just 7 years. Why?
So,
what's driving this boom? What makes it so attractive for investors?
well, one big factor, according to the source, is that TPLF returns are largely uncorrelated with, the stock market or the wider economy.
Ah, okay. So if the market tanks, a lawsuit payout might still happen. It's a diversification play.
Exactly. Kind of a hedge against that traditional market risk. And the returns themselves, they can be pretty substantial.
How substantial?
The source mentions annual returns often beating 20%. That's, way better than a lot of traditional investments offer.
Okay, that explains the money flowing in.
But here's a really crucial point from the source material. These funders, they aren't necessarily bankrolling like the classic David and Goliath cases just to help the little guy.
No.
They're strategically picking commercial litigation with a high expectation of success.
Okay, so less about pure access to justice, maybe, and more about finding cases that look like a really solid bet for a big return. The money's following the likely payout.
That distinction seems really key based on what we're reading here.
Okay, now let's dig into that invisible hand aspect. This lack of transparency feels like a really central and maybe problematic feature.
Oh, it's the defining challenge, I think.
Mm-hmm.
The hidden part comes from the fact that usually the legal paperwork, the complaint filed in court, it just doesn't mention that the plaintiff is getting outside funding.
So if you're on the defense side, you're just looking at the lawsuit as presented. No clue there's a financial backer involved.
Correct. And then it gets worse because TPLF agreements themselves are often considered not discoverable during the lawsuit.
Meaning you can't even force them to reveal it?
It's very difficult.
Yeah.
So even if you suspect TPLF is involved, getting details, who the funder is, the terms of their deal, how much control they might have, it's incredibly tough. It basically leaves the defendant, their lawyers, the insurance company, kind of flying blind about the real financial incentives driving the case.
That feels like a huge strategic disadvantage. I mean, typically the defense has to disclose its insurance policy limits, right? That's the pot of money potentially available.
Usually, yes.
But the plaintiff side, potentially backed by these deep-pocketed investors with their own return targets, they don't have to reveal their financial setup.
That asymmetry, that unlevel playing field, that's exactly what the source points to as a major consequence of the secrecy.
Okay, so given that imbalance, is anyone trying to change this? Are there moves to force disclosure, make this hand less invisible?
Yes, definitely. There's movement on a few fronts. Federally, the Litigation Transparency Act was introduced in the House February 7th, 2025.
Okay, Litigation Transparency Act, what would that do?
Simple purpose, really.
Right.
It would require disclosure of these TPLF agreements in federal civil cases.
That would be huge for federal litigation if it passes.
It certainly would. And in the meantime, some states aren't waiting for Congress. The source mentions Montana, Indiana, Louisiana, West Virginia, states that have already passed or introduced their own laws demanding more TPLF transparency.
So state-level action is happening. What about the courts themselves? Can judges demand this?
Some are starting to. The source points to the federal court in New Jersey, the District of New Jersey. They actually adopted a local rule requiring disclosure.
Interesting.
But, and this is important, the source stresses that's really the exception, not the rule. Most federal and state courts don't have anything like that in place right now.
So some progress towards transparency, but it's kind of patchy. Okay, let's shift focus a bit. Cyber claims. The source really argues that cyber is becoming like a prime hunting ground for TPLF. Why? What's so special about cyber?
It seems like a convergence of factors. First, cyber law is still evolving pretty quickly, lots of legal gray areas.
Yep.
And TPLF investors often see that kind of flux as an opportunity.
Opportunity for course.
Big payouts. Opportunity driven by recent court decisions that have been very plaintiff-friendly. We're seeing some really large verdicts and settlements in cyber cases. Funders follow the money, right?
And is there a particular type of cyber claim that's drawing them in?
Absolutely. The source specifically flags cases based on consumer privacy laws. Yeah. Things like California's Invasion of Privacy Act, CPA, or similar state statutes.
Ah, the big privacy class actions you hear about after a data breach or something.
Exactly those. They're generating some massive settlements. The kind the source talks about tens, sometimes even hundreds of millions of dollars. Right. That's very attractive to funders.
Why are those privacy claims suddenly so much more potent, maybe, than they used to be?
It ties back partly to a big Supreme Court case, Spokio v. Robbins, from 2016.
Okay.
Before Spokio, it was often really hard for plaintiffs in privacy cases to show they suffered a concrete harm, something tangible enough to even get their case heard in federal court. Just the risk of future identity theft wasn't always enough.
Right. Hard to quantify.
But since Spokio, courts have become, let's say, more willing to recognize intangible harms like anxiety, or the cost of credit monitoring as being concrete enough.
So it lowered the bar for plaintiffs to bring these kinds of privacy harm cases?
Pretty much. And then you add laws like SEPA in California, which go even further. They allow for statutory damages.
Meaning
a set dollar amount per violation without the plaintiff even needing to prove they suffered actual financial loss or quantifiable harm.
Wow. Okay. If you don't have to prove individual specific harm, just that a rule was broken for lots of people.
It just makes launching massive class actions or mass arbitration campaigns way easier.
That sounds like fuel for TPLF.
Absolutely. That's why the source connects SEPA directly to these huge nine-figure settlement demands. It shifts the game from proving individual damage to just proving, often, a technical violation happened at scale.
And the tech itself, like website trackers, that plays a role too.
Oh, definitely. The rise of ad tech, pixel trackers, all that website monitoring. It's created brand new ways to sue. Plaintiff firms, often with TPLF backing, are using laws like SEPA or even older laws like the Video Privacy Protection Act in new ways based on how websites gather user data.
So suing over how the website works, essentially.
Often, yes. And proving a technical violation of a privacy statute can be much simpler, much more straightforward than proving complex individual damages like identity theft losses.
It also sounds maybe easier to find plaintiffs for these cases.
It can be. Websites are public, their privacy practices can be scrutinized, and big, publicized data breaches instantly create this large pool of potential plaintiffs. For the funders and the law firms, it's often a lower barrier to entry to get a large group together.
And the companies being sued, are they part of the calculation?
For sure. Big, well-known corporations are often targeted. Why? Their brand reputation makes them vulnerable. They might settle faster just to avoid bad PR, which funders like.
Quick return.
And they're seen as having deep pockets, right? Even if the individual claim isn't huge, the thinking is they can afford a large settlement.
Okay, now here's where the source gets maybe a bit more alarming. It talks about non-traditional funders, specifically foreign competitors using TPLF. What's that about?
Yeah, this is a really critical point the source brings up. There's a serious concern that foreign companies could potentially use TPLF, not just for the lawsuit's financial return,
Uh-huh.
but as a way to get access to a U.S. competitor's confidential information through the discovery process.
Wait, really? Using a lawsuit funded by TPLF as a kind of corporate espionage tool to get trade secrets via discovery requests?
That's the potential risk the source highlights. It even mentions a specific case. Samsung suing a Chinese funder, Purplevine, in Texas last year. Samsung alleged Purplevine misused confidential info it got during discovery in a different patent case it was funding.
Wow. That adds a whole other layer to this. It's not just about the money from the settlement. It could be about strategic intelligence gathering.
It certainly raises the stakes quite a bit. So you put all these pieces together, the evolving law, the statutory damages, the tech, the ease of finding plaintiffs, the attractive defendants, even this espionage risk, and you can see why cyber, especially privacy claims, looks like such fertile ground for TPLF.
Okay, so we have this booming, often secret funding source zeroing in on cyber claims because the conditions are right for big payouts. How does this invisible hand actually make things more expensive for everyone?
Well, the source is pretty direct about it. TPLF inflates litigation costs, period. It doesn't just fund cases that would have happened anyway. By injecting capital, it encourages more lawsuits to be filed than might otherwise have been viable.
And it fuels something the source calls social inflation. What's that?
Social inflation is basically the rising cost of insurance claims that isn't due to normal economic inflation, but rather things like changing laws, bigger jury awards, shifts in how people view corporate responsibility, claimant behavior.
Non-economic factors driving up costs.
Right. And TPLF is seen as a major contributor to social inflation, particularly in areas like cyber, because it makes these really long, expensive, high-stakes lawsuits more common.
How does it change the game plan for the plaintiff side?
Think about it. TPLF essentially removes a huge constraint for plaintiffs and their lawyers. Normally, they have to constantly weigh the heavy upfront costs paying experts, depositions, court fees, preparing for trial against the uncertain chance of winning.
But if a funder's covering those bills,
Then the plaintiff's lawyer doesn't carry that financial risk personally. They're freed up to focus purely on the legal fight.
which probably means they have less reason to settle early just to stop the bleeding cost-wise.
Exactly. It makes going the distance, pushing through extensive expert discovery, fighting summary judgment motions, even taking the case all the way to trial much more financially feasible, even attractive for the plaintiff's team.
Yeah.
They can afford to be patient and fight harder.
And what does that do to settlement talks?
Well, if the claimant side isn't feeling the financial pinch, isn't facing deadlines driven by their own funding needs, they're generally going to be less willing to settle early or for a lower amount. The source suggests TPLF involvement tends to push overall settlement values higher.
And we're back to that asymmetry again. The funder knows the insurance policy limits,
Right, which are usually disclosed.
but the defense side has no idea what the funder's minimum required return is or how much control they have over settlement decisions.
Exactly. That information gap lets the funder play hardball, leveraging the known insurance limits, while the insurer and the defendant are negotiating partly in the dark. Plus, think about incentives. A policyholder might want to settle quickly to avoid bad press. An undisclosed funder, they don't care about that. They just want the biggest return, even if it means a public trial.
Is this cost increase just hitting cyber, or is TPLF popping up elsewhere too?
Oh, no, it's broader than cyber.
Yeah.
The source mentions TPLF is very active in commercial auto liability, D&O insurance, professional liability, product liability.
So across the board in commercial lines.
Yeah. There's even a stark example in the source material about a commercial auto insurer that reportedly just pulled out of that entire line of business because the litigation costs, driven partly by TPLF, became unsustainable.
Wow. So when all these extra costs pile up longer cases, higher settlements, who actually pays in the end?
Well, while the funder gets their cut from the win, the extra expense generated by the whole TPLF dynamic, that prolonged litigation, those inflated settlements that ultimately gets absorbed by policyholders through higher premiums, by consumers through higher prices for goods and services, and by the insurance carriers themselves. It ripples through the system.
Okay, so TPLF, powerful, often hidden, growing fast, loves cyber liability, and it's clearly pushing costs up. What can the cyber insurance market actually do about it? How can they respond?
The source suggests it's got to be a multi-pronged strategy. First, really double down on encouraging insureds to beef up their proactive risk management.
Prevention is better than cure.
Yeah. Exactly. Strong cybersecurity is baseline, obviously,
Yeah.
but also really focusing on fixing the practices that lead to these TPLF attractive privacy claims, like the website tracking stuff. Cut off the fuel supply, basically.
Makes sense. What else?
Then, when a claim does come in, carriers need claim management processes that are specifically aware of the potential for TPLF being involved. It changes how you might handle those initial stages.
And the lawyers you hire.
Absolutely critical, the source says. You need defense counsel who aren't just cyber experts, but who specifically understand TPLF, can spot the signs, and know the right strategic responses. A different ballgame.
Then trying to figure out if TPLF is actually there, even if it's not officially disclosed.
Yeah. Until disclosure becomes mandatory everywhere, the advice is for carriers and their lawyers to actively try and find out if TPLF is backing the plaintiff. Maybe through informal questions, maybe through clever initial discovery requests where the court allows it. You need to try and pierce that veil.
Which brings us back to those laws we talked about earlier.
Precisely. Widespread mandatory disclosure, whether federal or state, would be a massive help. It gives everyone critical information right from the start, allowing for, more realistic assessments and negotiation strategies.
So let's try and wrap this up. Third-party litigation funding. It's this huge, often hidden, rapidly growing force. It's strategically targeting cyber liability, especially privacy cases, because the legal landscape and potential returns are favorable.
Right, and this invisible hand is significantly boosting litigation costs. Think social inflation, longer disputes, tougher negotiations, creating a real imbalance.
But the cyber insurance market isn't helpless. They can respond through better risk mitigation by insureds, smarter claims handling, using defense lawyers who get the TPLF angle, trying to uncover funding arrangements, and supporting those efforts for transparency through new laws and court rules.
That sums it up pretty well. It really underscores how outside money can dramatically change the legal playing field, often without the original parties even knowing the full picture.
And it really leaves you with a big question to chew on, doesn't it?
It absolutely does. If TPLF lets these secret investors who have no connection to the original harm influence lawsuits, maybe even use them to get sensitive corporate data, and definitely drive up costs for everyone, how does the legal system strike the right balance? How do you weigh the potential benefit TPLF claims providing access to justice against the very real need for transparency and preventing these kinds of market distortions and, frankly, strategic risks?
It's a tough balancing act.
It really is. And with TPLF showing no signs of slowing down, it's a question that's only going to become more urgent.